Hello students and welcome to the lecture. So students, as we know that we are covering the center and the state relations, all right? So basically in this lecture, or you can say that in this particular series, what we are covering here, we had scheduled these topics for the discussion, like starting with the introduction part, thereafter the legislative relations, thereafter the administrative relations, thereafter the financial relations, thereafter the trends in the center state. Okay? So you could say that these are the topics we have scheduled for the discussion. Starting with the introduction, we have finished it. Thereafter, we will discussing about the legislative relations. All right. And the topics which we are left with is the administrative relations, financial relations, and the trends in the center state relations. All right. So basically, we will continue from where we had left in the previous lecture. I hope that you have revised the previous one in the well enough manner before you have come for this lecture, as many times I have told you that it is for your own benefit. So if you are not doing this on the regular basis, the thing will be difficult for you to catch up. Why? Because remember, all of the things which we are covering here, they all are interconnected with each other. Okay? They all are interconnected with each other. So let's start from where we had left. Basically, we had discussed that there are five parliamentary powers. Okay, or not parliamentary powers. Basically, there are five conditions in which the parliament could take over the powers of the state legislatures in terms of making rules and the regulations over the provisions enumerated in the state, right? In the state list. So first thing is that when the Rajya Sabha, which is the representative of state to the parliament, they passes a resolution, but that's required the 2 by 3rd majority of the members present and voting to pass the resolution. And after passing of the resolution, both the parliament and the state legislature could make the laws over the provisions of the state. Okay, because we had seen that that particular, you can say, thing does not restrict the state legislature powers on making the rules and the regulations over the provisions of state. But if there will be any conflict arises between the central laws and the state laws on the same topic, so always the central law will take over the state law. Okay, that is also we had discussed. And basically we had discussed that this particular provision could only be existed for maximum 1 year. Thereafter, again the new resolution has to be passed. And if no new resolution has been passed and the 1 year has been completed, it means that only 6 months after the completion, the provision and the laws of the central government could work over. After this, they all will be expired. Okay. So this is the you can say the quick and a little bit revision of the things which we had discussed in the previous lecture regarding the topic. Okay. Now, second is during a national emergency. All right. So basically, in our Constitution of India, we had the Article 352. Okay. Article 352 of the Indian Constitution provides for the national emergency on grounds of three things: war, external aggression or aggression, and armed rebellion. War, external aggression, and the armed rebellion. On these three things, the national emergency could be imposed. All right. So basically, the parliament acquires a power to legislate with respect to the goods and service taxes or matters in the state list while a proclamation of national emergency is in operation. Okay. So basically, when we were discussing about the you can say the state and the central powers over the GST, we had discussed that center could charge the powers when the trade is interstate. Okay. Interstate means between the states. All right. And the state could charge the power when the trade is intrastate. It means within the state. All right. So whenever there is a national emergency in the proclamation or in the action, so center or the parliament will exercise the powers on the both, whether it's interstate or intrastate. Both the things will be fall off to the parliament. All right. Thereafter, the laws become inoperative on the expiration of 6 months after the emergency has ceased to be operative. Okay, it means that once the emergency will be withdrawn, the powers will be transferred to the state legislature again, and within the 6 months or after the 6 months, the provisions which had been made by the parliament regarding the same will be vanished. All right. Here also, the power of a state legislature to make laws on same matter is not restricted. It means that doesn't mean that if the powers of the intrastate trade had been transferred to the parliament, then the state legislature is not allowed to make the rules and regulations on the topic. The state government could also make the things. But again, the same thing is here. If there is any repugnancy between the state law and the parliamentary law, if there is anything like this, so always the parliamentary law will have the supremacy. All right. Always the parliamentary law will have the supremacy. Okay. Got it? Thereafter, third condition we have is when states make a request. Okay. Please do not get confused with the Rajya Sabha. Mostly people get confused that the two provisions are the same. When the Rajya Sabha makes a request and when the state make a request. No, they don't. You can say they are not the same. They are different. Like Rajya Sabha is the representative of state. All right. It is a representative of state. Got it? It's not a individualistic of states. But when we talk about when the state makes a request, then basically it is done on the individual basis. Got it? It is on the individual basis. Like individual states, apart from the Rajya Sabha, they are making a request. Okay, so please keep this separate. Rajya Sabha is the representative of states combinedly, but this provision is for the individual basis. Okay, states individually requesting the parliament. All right. When the legislature of two or more states pass the resolution requesting the parliament to enact laws on a matter in the state list, then the parliament can make laws for regulating that matter. All right. It means that suppose there are total 28 states in India. Out of this, for example, four states they reached the parliament and they requested that the parliament should make the laws on the matters of state list. Okay. So if these four states are making the request and the rest 24 are not, okay. So whatsoever the laws the parliament will make, these laws will only implicable in these four states which had making the request. Okay. While when the Rajya Sabha, when the Rajya Sabha will make the request, then provision will be implemented in all these states. Okay, so that is the difference. It means when the states makes the request, only the selected states will have the implication. and the rest states will be working as normal. But when the Rajya Sabha makes the request, then both the states, selected or non selected, or you can say state in the combined form, it means all the 28 states will have to bear the consequences and the implications. All right. So that's the thing. A law so enacted applies only to those states which have passed the resolution. As I have told you, if there are 4 states which had passed the resolution, the laws will be implicated or implemented only on those 4 states. Okay, the laws have nothing to do with the rest states. However, any other state may adopt it afterwards by passing a resolution to that effect in its legislature. Such a law can be amended or repealed only by the parliament and not by the legislature of the concerned state. Alright? It means that there is one thing. Like suppose in starting, only the 4 states had made the request. Thereafter, one more state joined them. So how many states are there in total? Total there are 5 states. Okay? It means that if any other state which was not in the group of those states which had made the request, if any other state wants to join the group, then they could join the group. But after passing resolution for the same. All right. After passing resolution for the same, they would join the group. First thing. Second thing which you are required to hear is that always remember that whatsoever the provision would be made on the transferred state matters. It means that those matters which had been transferred to the parliament after the request, whatever law and the resolution would be passed on them, only the parliament would have the implications on them. It means that the right to amend or repeal those provisions, the power is only lies with the parliament. Okay? No longer the state legislature could exercise their power on it. Okay? So remember this thing. The effect of passing a resolution under the above provision is that the parliament becomes entitled to legislate with respect to a matter for which it has no power to make a law. Okay? It means that prior to the request, the parliament having no power to make the matters, to make the provisions on the matter. Why? Because the powers were rested with the state legislature, right? Because the things were in the state list. But after the request, the things were transferred from the state list to the parliament, right? And it means that the parliament now having the power to make the rules and the regulations on it. Priorly, they haven't. All right. But on the contrary to it, and you can say on the other hand, the state's legislature ceases to have the power to make a law with respect to that matter. It means that the state legislature initially had the power to make the provisions on the list. All right. But once they had transferred the things to the parliament and you can say requested the parliament to make the rules and the regulations on it, so basically they had lost their powers to make the provisions on it. So remember, Suppose if four matters of state list had been transferred. All right. So there are two things: Parliament and the state legislature. All right. The Parliament having the power, or you can say gaining the power to make provisions on the matters priorly they hadn't. Gaining the power to make provisions on the matters priorly they hadn't. But state legislature are basically restricting the power to make provisions on matter priorly they had. That's a thing. Okay. So that will be a change, or you can say the implicated change between the both the parliament and the state legislature. The parliament will gain the power to make the provisions on the matters which they haven't, but the state legislature will restrict or losing the power to make the provisions on the matter which they have. All right. So that is the thing. The resolution operates as an abdication or surrender of the power of the state legislature with respect to that matter, and it is placed entirely in the hands of parliament, which alone can make legislation and respect to. Like on the previous one, in the previous one or the previous two cases, what we have that when the Rajya Sabha makes a request, all right, and second one was during national emergency. Okay, so two things we have when the Rajya Sabha makes a request, and second one was during national emergency. All right. In both the scenarios, there were basically two things. First is Parliament could make provisions. Second was state legislature could make provisions. It means they both having the power to make the provisions. They both having the power to make the provisions, whether the parliament or the state legislature. But still we know that the parliamentary laws having the supremacy. Like if there is any conflict and overlapping or replicating, the parliamentary laws will always have the supremacy over the state legislature. That is what we had seen. But when we talk about this one, okay, it means that when we talk about the third case, which is when the states makes a request, okay, then always remember that only the parliament makes the provisions. Only the parliament will make the provision. All right. It means the state power or the state legislature power to make the provisions on this is totally abolished. Only the parliament will there. But in the other two cases, when the Rajya Sabha makes a request and the during national emergencies, the both could make the provisions on the same topic. But yes, there was a supremacy which had been transferred to the parliament. In case of any disagreement, restrictions, or overlapping, the parliamentary laws will have the supremacy. Okay, so remember all these things which I had shown you. Some examples of laws passed under the above provisions, like the Prize Competition Act 1955, Wildlife Protection Act 1972, Water Protection and Control of Pollution Act 1974, Urban Land Sealing and the Regulation Act 1976, and Transplantation of Humans Organs Act 1974. All right. So these are the notably acts which were passed when the states make the request to the parliament to make the laws and the regulations on. Please remember these acts. Maybe the question asked in the examination like which particular acts were formulated when the states request the parliament. All right. After this, the fourth thing which we have here, to implement international agreements. Okay. To implement international agreements. What is this? The parliament can make laws on any matter in the state list for implementing the international treaties, agreements, or conventions. This provision enables the central government to fulfill its international obligation and the commitment. Okay? It means that once the matter comes for the international agreements, which were always be signed by the national government. Remember, only the national government is allowed to make the treaties with the international governments. However, the state governments will also do this thing, but they are required to take the approval of the national government. Until or unless the national government's approval is not given, they could not make any agreements with the foreign entity. Okay, so here is written down the parliament, which is signifies the central level. The parliament can make any laws on the any matters or the state list. Okay, if the topic is for the international treaties, agreements, or the conventions. This provision enables the central government to fulfill its international obligations and the commitment. All right. Some examples of laws enacted under the above provisions are the United Nations Privileges and the Immunities Act 1947, Geneva Convention Act 1960, Anti-Hijacking Act 1982, and the legislations which are relating with the environment and the trips. Okay, these are the things on which the central government could directly take up the charges. The parliament could directly take up the charges, and there is no formal invitation given to the state legislature. Why? Because it is a matter of fulfilling international obligations and the commitments which are in the national interest. All right. So remember this thing. Thereafter, during the president's rule, okay, the president rules is basically signifies by Article 365. All right. So when the president rule is imposed in a state, the parliament becomes empowered to make laws with respect to the any matter in the state list in relation to that state. A law made so by the parliament continues to be operative even after the president rule. This means that the period for which such a rule remains in force is not coterminous with the duration of the precedent rule. But such a law can be repealed or altered or reenacted by the state legislature. Alright. So remember, Article 365 of the Indian Constitution provides for the President rule. It means that if the President feels that the state government is not capable to work as per the center's direction, then the President rule could be imposed. If the President rule is imposed in any of the state, it means now Parliament will get the power to make the rules and the regulations regarding the subjects of the state list, but of that particular state only. It means that suppose if there are two states, Uttar Pradesh and the state of Punjab. All right. So in Uttar Pradesh, president rule has been imposed, but in Punjab, there is no president rule has been imposed. So it means that the parliament is only allowed to make the provisions on the state list matters of the Uttar Pradesh. They could not go to the Punjab. Why? Because it is only for the respected state list of that particular state. Only that particular state could be affected. All right. And the one thing which we could see here, that there is no prescribed time duration. There is no prescribed time duration for it. It means, what does it mean? It means that even after the removal of the president rule, okay, it means that the president rule, once it was imposed in the state, then the parliament could make the laws. And after the, you can say, revocation of the president rule, it means that president rule is no longer existed in the state. Even after the laws which were made by the parliament would be prevail as it is, until or unless they were repealed, altered, or reenacted by the state legislature. All right. So that's why it is said that there is no prescribed time duration for the president's, for the provisions which were made by the parliament or the central level during the president's. Okay. So students, basically in this lecture we have finished till here. In the next lecture we will continue from here. Till then, just revise all the facts and figures which we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture, and what we say, we say